It's 5:30. I will call the Planning Commission meeting to order. Please call roll.
Good evening, everyone. Chairman Baugh,
Here.
Vice Chairman Dibble,
Here.
Commissioner Schrader,
Here.
Commissioner Zarguni,
Here.
Commissioner Miller, absent, Commissioner York,
Here.
Commissioner Gonzalez,
Here.
Commissioner Mandel,
Here.
and Commissioner Salazar Garza.
Here.
Quorum established.
Thank you. Do you have an opening statement? No? Thank you. Moving on to approval of absences. There are none, so we're moving to approval of minutes. Do I have any comments or a motion?
I'll make a motion that we approve the minutes as presented.
I'll second it.
All in favor, say aye.
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 All opposed, same sign. Motion passes. Moving on to consent public hearing items A and B. At this time, I would like to pull item 11 from the consent.
Commissioner, if I may, I
Please.
think we accidentally skipped over public comment.
I apologize there. For the minutes? Is that, no, we got the minutes. Oh, I did skip over. Are there any overall public comments at this time? Are there any comments not related to any specific agenda item? Seeing none, I will close the public comment portion. Thank you. All right, at this time, we will pull item 11 from the consent and hear items 2 through 14. Yes, sir.
Okay, for the record, David Stallworth, Senior City Planner. And I'd like to call to your attention agenda Roman numeral number 5, the consent agenda for tonight's meeting. It consists of 13, one of which has been pulled, 13 items, 9 of which are plat-related and 4 of which are for zoning matters. With the plat-related items, the first one is Weber Plaza final plat, subdivision, Block 3, Lot 28R. The second item is Cottages by the Bay, Unit 2. It's a final plat. The third one is a final plat of Padre Island, Corpus Christi, Section Number 4, Block 236, Lot 13R. It's a corrections, a replat. The fourth item is Azalea Estates, Unit 2. It's a final plat. The fifth item is a replat of Saxett Heights, Block 6, Lot 19R. The next item is a final plat of London Town Subdivision, Unit 6. The next item is London Town Subdivision Unit 7. It's a final plat. And next item is Riverbend Subdivision. It's a preliminary plat. And the last item is a request for a time extension of Coastal Community and Teachers Credit Union, which is a final plat. The following items, which are zoning related, number 11 has been pulled. Number 12 is a request for rezoning under case number 0521-01, Kitty Hawk Development Limited. It's a case to rezoning property at or near 9142 Staple Street, located along the southeast corner of South Staple Street and County Road 41. The zone change request is from the CN1 Neighborhood Commercial District to the RS15 Single Family District. The next rezoning item is a public hearing to review a zone change request, case number 0621-02. Petitioner is Glenn Lyons. The request is to rezone property at or near 5839 Williams Drive, located at the southeast corner of the intersection of Williams Drive and Bracewood Drive, east of South Staple Street. The request is to rezone the property from the RS6 Single Family 6 District to the ON Neighborhood Office District. And the final item on tonight's consent agenda is a request for a rezone, case number 0621-03, Monegassi Investment Trust. It's a request to rezone property at or near 2302 County Road 43, which is located along the east side of County Road 43, west of Yorktown Boulevard, and south of Farm to Market Road 43. The petitioner is requesting a rezone from the FR Farm Rural District to the RS 4.5 Single Family 4.5 District. This concludes my presentation. Do y'all have any questions at this time?
Thank you. Do any commissioners have any questions for staff regarding items 2 through 14, less number 11?
I do have a question on number 12.
Yes, sir.
In regarding to the change of zoning to the commercial, knowing that area that's pretty much surrounded by a lot of the single-family homes and no utilities out there right now, I'm assuming that the applicants are gonna,
To
Develop-
clarify, Commissioner Zargini, it's from commercial to residential. It's just noted wrong on our agenda. Is that correct?
That is correct. There was an oversight. We didn't catch that in time, but there is a mistake, and it's been, for the record, the correct project description was mailed out, and the legal ad will reflect the correct project description.
okay, so I guess my question now is, changing the zone into RS15, does that require service utility out there, like sewer? Because that area does not have sewer. So RS15 zoning, does that require sewer, or can they operate under septic?
Yes, I can address that, Commissioner. Andrew Demas with Development Services. The adjacent subdivision, it is within the city limits. It does have access to utilities. A part of it is going through the plating process as we speak, which would entail the public improvements, the extension of those utility lines.
Okay, thank you.
Yes, sir.
Thank you. Any other questions for staff? Seeing none at this time, I will open the public comments for items 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, and 14. Would anybody wish to speak? Seeing none, I will close the public comment and entertain a motion for those items or further discussion.
I'll make a motion that we approve items 2 through 10 and 12 through 14 as presented by staff.
I'll second.
All right, I have a motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. Motion passes. All right, moving on to item 11.
Good afternoon, Commission. Craig Garrison, City Planner for Development Services. I'll be presenting item number 11, which is a, oh, 1 second. Let me pull up the PowerPoint, 1 second. Are you able to see the PowerPoint on your screens? Thank you. This is a rezoning, zoning case 0621-01, a rezoning for a property at 13845 Mizzen Street. It's zoning from the RS6 Single Family District to the RS6 Special Permit for a bed and breakfast home. The zoning pattern in the area is that of typical RS6 Single Family Residential and RS6 Planned Unit Developments. The UDC requirements are, there are no UDC requirements for buffer yards, as this is a RS6 special permit, and it's a bed and breakfast home with no, commercial activity. The setbacks will be 25 feet from the street, 5 feet from the side, and 20 feet from the rear, which is from a bulkhead. The uses allowed will be single-family detached housing, a daycare home, educational facilities, and place of worship. And I do want to correct this use is allowed as the definition of a bed and breakfast home in the Unified Development Code states that it will be just a bed and breakfast home and no longer a single family home. Utilities in the area are a 6-inch PVC for water. Wastewater has 8-inch VCP. Gas has 2-inch service line. And stormwater has a 30-inch RCP line to properties down the street. For the bed and breakfast home requirements, I do want to go line by line because it's important to know all the requirements as far as operating this, this business from this site. So this is from section 5.2.8, bed and breakfast home. Item A, a sleeping accommodation shall not exceed 5 bedrooms and no more than 10 lodgers shall be accommodated at one time, not including the owner, which shall have an occupied room. Kitchen and dining facilities may be included to provide meals to guests only. No food preparation shall be permitted in guest bedrooms. Parking in the street yard of a bed and breakfast shall be prohibited. All parking shall be screened from an adjacent residential use by an opaque fence or a hedge a minimum of 6 feet in height. In residential districts, no exterior evidence of the bed and breakfast home shall be allowed, except that one attached sign no larger than 1 square foot in area shall be permitted with no additional advertising of any kind allowed on site. In non-residential districts, the sign provisions of Section 7.5 shall apply. The operator shall keep a current request register or ledger, including names, permanent addresses, dates of occupancy, and motor vehicle license numbers for all guests. A temporary use permit in accordance with Section 5.4 shall be required for any party, reception, or similar special event that is anticipated to draw more than 10 total guests, including overnight guests, to the bed and breakfast home. Special events subject to the temporary use permit shall be limited to a total of 6 such functions per calendar year and shall be limited to between the hours of 7 a.m. and midnight. Such events shall be limited to the interior of the bed and breakfast home. And lastly, the bed and breakfast home shall not be closer than 1,000 feet to any other bed and breakfast home. So the applicant that has applied for the RS6 special permit bed and breakfast home have indicated that they plan on using all these standards and applying all these standards. If it does receive the special permit, then it will be up to code enforcement with the city of Corpus Christi to enforce these provisions of the UDC. And for UDC requirements that are shown to be met with their site plan on the right, it shows that a max bedrooms are 5 and they have 3 indicated on the site plan. There's no on-street parking, and they do show 4 off-street parking spaces that shall be screened by, listed here, oleanders or palms. And then other requirements shall be met at a future time. As we turn to the public notification slide, 20 notices were mailed inside the 200-foot buffer. 1 notice was mailed outside the 200-foot buffer. We have received 8 letters in opposition, totaling 38.84%. This is 7 separate owners, as 1 property owner has 2 homes on the street. We received 0 letters in favor. And our staff recommendation is approval of the RS6 Single Family 6 District with a special permit for a bed and breakfast home. Any questions?
Thank you. At this time, are there any questions for staff regarding item 11? Are there any other bed and breakfasts in this area at all?
I do believe there's just 1 bed and breakfast home here in Corpus Christi. I do believe my colleague Andrew Dimas knows the location.
Yes, there's the Ocean House on Ocean Drive that is conforming along with this chapter of the code as far as a bed and breakfast home.
Thank you. Any other questions for staff? Okay, at this time, I will open the public hearing portion. If the applicant is here, we'd like to hear from the applicant first. And if not, all other members will be allowed to speak. So is the applicant available?
He indicated that he would not be available for this meeting.
Thank you. All right, at this time, any other members that would like to speak on this item? There is a timer set just for time constraints, but anybody wishing to speak, please come to the podium and state your name and address for the record.
Good evening, ladies and gentlemen. I am Gary Kleprick. I am the Executive Director for the Padre Isles Property Owners Association. Our offices are at 14015 Fortuna Bay Drive. And I am here by the request of my homeowners to represent their view of this rezone and to express to you that they wish it to be declined for reasons that having a bed and breakfast or any other short-term vacation rental activity within the residential area, single family of our POA is of a nuisance and is highly disruptive to their lifestyle as actual homeowners. I'm also here to express the view of the POA and the Board of Directors of the POA, as not only is the disruption to adjacent homeowners or even the homeowners on the street, it is also a disruption to the entire community as well, because the influx of short-term vacation rentals places a negative impact on the community itself, especially when these vacationers are demanding services from the association in the use of our boat ramps and other public facilities. And that strain not only puts a burden on the association financially and logistically, it also hampers the ability of actual homeowners to use those facilities as they themselves pay for them with their assessment dollars. So at this point in time, we would like to go on record to ask that this be declined. And I would also like to kind of plant the seed as far as any future planning on this, is we would like to convey the feeling to this board, this esteemed board, that there is a significant difference between a piece of property and a home, okay? And we would like that you graciously accept our view that a home and the rights of a homeowner should always supersede that of a property owner whose interest is to make short-term vacation rental income or revenue. Thank you.
Thank you.
Hi there. My name is Dusty Gordon, and I'm a homeowner out on the island. Right now, the state definition of a bed and breakfast means that it has to have 7 or more bedrooms. They also have to provide food service. And with providing food service, that means that they must meet an undue hardship or following food and health regulations for the people staying there. Also, the Texas Supreme Court has ruled that a short-term rental does not change a home from being single-family use, residential, to commercial. Also, what I saw in the presentation, preventing parking on the streets, that's a public right-of-way. As long as a car is within the regulation that it's supposed to be, registration insured, you cannot prevent any number of vehicles from parking in a public right-of-way. I, along with many other homeowners, are okay with short-term rentals. I don't know what comes out from the POA, but there's a lot of different things going on. And they were talking about money not being spent correctly, logistical problems. We would actually like them to see them use the money that we give them to take care of our island, which has not been being done. That's all. Thank you.
Thank you.
Good evening, Commissioners. My name is Robert Tortorello. I live at 13846 Halyard, which is directly across the canal from the proposed property. I'm going to get a little more personal into this. I understand the logistics, how challenging that can be, and the nuisance with excess trash, you know, flying out of the yard. You have, the room is just not there. And it gets even more personal for me. This is a 2-story home. It has a master bedroom up on the northeast end of the house with a large view. And I can't even enjoy my own patio out there. I've been sitting out there. There's folks that are, you know, taking apart in lewd acts. It's just very disruptive and very uncomfortable. There's noise at all hours of the night. There's spotlights that remain on, and that's against the POA rules in itself. But they just don't, they don't hear, they don't understand. I'm thinking that there's some ignorance there, but I've had to get out of bed at 10:30 at night and ask these folks to turn the darn lights off multiple times. So it's very uncomfortable, and that's not what we signed up for. And I hope you consider rejecting this. Thank you.
Thank you, sir.
Hello. My name is Renee Tortorello. I live at 13845 Halyard, across the canal from this property. as stated, numerous times, there's like strangers on a daily basis. There's no code enforcement now. So my concern is what kind of code enforcement is it going to have in a bed and breakfast with all the things that they were talking about earlier? This house right now is being rented out on a daily basis. There's strangers constantly in our backyard. There's lights shining in our bedroom window all hours of the night. As he stated, you have to go knock on the door and request for the lights to be turned off. We have seen lewd acts. I've heard comments. You're not even comfortable in your own backyard. This is my personal home. I did not buy this home here to live with this. Constant revolving door of strangers. You don't know what kind of backgrounds coming in and out of this property. I have grandchildren that live next door to this property, and it's just, I really hope you consider rejecting this idea. It's just not what this is meant to be. This is our home, not a commercial area.
Thank you.
My name is Jeanette Protzeller. I live at 13850 Halyard. This house...
I'm sorry, could you pull the mic
Sure.
down? Thank you.
This house is directly, diagonally across from me on the canal, so you have a visual. So this is what I get to look at every day. Now, this was a renter here this past weekend. They had a no zone, wake zone. He came flying in down the canal. Boats were going back and forth, and it's a huge safety issue for me because those two kids live with me at this house. We have ties to the community. They're at Seashore Learning Center. I went and looked at condos when we moved to the island. If I was single, if I didn't have any kids, that would be the lifestyle for me. I actually have a hotel, restaurant, institutional management BS degree from Virginia Tech. I am all for hotel management, but not in a residential, single-family home. We have transient traffic coming in every single day. Since these people, the Moraleses, bought it in November 2020, it has been rented out every day from $144 a night to $499 a night. And they have it listed, and I could find, on 8 websites so far. And in B&B is somebody that is there on the property. They didn't even show up for this. So if there's a problem, they're not there to fix it. It's up to us. And then they were supposed to post a sign for this meeting, and it was behind the mailbox, upside down, next to the fence. So I wrote an email, and I said, hey, it's not visible from, the street. And they said they would come out and fix it, but now it's gone. So this is what it looked like from the street. So I'm just asking, since this is our homes, these people are on vacation 24/7, but we're not. It's loud noise pollution. You got, they advertise on a barking dog website, pet friendly, so you got barking dogs. You got canal pollution of cigarette butts, bottles, beer, cans, fish offal thrown in. You got bright lights coming in because they have all the floodlights on. And then you have the reckless boating. We all know where the kids are. They have grandkids right across the canal, right next to them. I have little kids there. We're all in the canal. Last year, when everything was closed down, you couldn't go to the beaches, you couldn't go to the park, the big deal for that 9-year-old right there was to get on a paddleboard. And we all had our phones on the docks, and they would get on their paddleboards, which were surfboards with paddles, and they would go to the house that was in the middle, and that was a big deal for them. And then there's a kid on the other end, and they're all at Seashore Learning Center. But we don't need transient traffic every single day and not knowing who our neighbors are. Thank you.
Thank you.
Good evening. Just like everything else has been said, I live at
Could you-
right next door, 13841 Mizzen.
And you,
Ben Tortorello.
thank you.
I've got the kids, they're grandkids. I've had people lean over the fence and ask my kids, they're 7 years old, hey, can you help me take this fish off? I don't know what I'm doing. Like, you're a stranger. You have no business walking over my bulkhead and talking to my kids. This is outrageous. I've had my wife up on the upper deck just outside enjoying a beer, just chilling out Friday night, and college kids yell up at her, "Hey, girl, what's going on tonight? What are you doing?" I'm not going to live in a house like that. That's outrageous to even think that's acceptable. Every Friday, when I come home, instead of coming home and enjoying my time, I pick up the trash out of my yard because I put up both cans out on the street and they blow everywhere because they overload it. They got bags that are on the street. The weeds in the yard, all of it. It's crazy. And I think we can tell how outrageous it is, and I don't have anything else to say, but that's nuts. Dogs barking all night long. Lights, music, beer bottles, trash. It's nothing good about it. Zero.
Thank you. Anybody else wishing to speak? All right, at this time I will close the public comment portion. Any other conversation or questions?
I have some questions for staff on clarification of some legal issues. So, has anything changed with the state's mandate that we can't regulate short-term rentals?
At last bill that, according to our Intergovernmental Relations Office, the only bills that were moving through the legislature, we haven't got final word if they were passed, was just simply cities could not prohibit short-term rentals.
Okay. What means do we have from a code enforcement standpoint to regulate homes being operated as short-term rental?
Sure, absolutely. So by code, in the Unified Development Code, it states that the minimum rental period for a single-family home in a single-family district is 30 days. If they are renting for less than that, that is a violation of the zoning section of the ordinance. And it can be handled through code enforcement as a citable offense.
Say that again, please.
So the verbatim definition within the Unified Development Code of what is a rental home is a single-family home in a single-family district must rent for a period of no less than 30 days.
But these, I mean, it's my impression that this is being being rented out on Airbnb or whatever the sites are that where the state has defined we can't regulate that. So that's it's not a rental property. It's a short-term rental and
It's still a rental,
undefined.
so it still would classify under that definition, and therefore code enforcement could begin an investigation and ultimately a citation.
Okay, and so the residents can actually call these incidents in on
Absolutely.
code enforcement as a residential property.
That's correct.
Okay, does the bed and breakfast regulation provide more enforcement authority than the current situation?
Yes, the bed and breakfast section, in this case home, it must be owner occupied by definition, and that is the difference from the complaints we do hear every day about short-term rentals, is that these are off-site folks that own the property. In this case, in order to be compliant with this section of the code, if they are successful with their zoning, they must be owner occupied, meaning at any time either our staff, compliance officer, or any member of code enforcement can visit the property and ask that they produce all the required items. So for instance, as Craig mentioned, the registry of the clients that are staying there, they have to provide that. And of course, they must be on site to produce those documents. If they are not, they potentially are in violation of the code.
And then what are the ramifications?
Ultimately, they could lose their overlay designation. So this entire zoning process, if they become non-compliant and choose not to rectify it, they lose that status as a special permit.
Okay, so if we don't approve this bed and breakfast, what changes to their current operating situation?
Ultimately, if they are still, and if you can imagine whether or not this passes, if it is not owner occupied, and of course if they're renting less than 30 days, it's a violation of the UDC. If the zone is successful and they're still not owner occupied, it is a violation of the UDC. So no matter what, that issue of not having somebody on site is a key point.
Okay, so I still think I'm not too clear on this less than 30 days issue. I thought that can't be regulated.
What the legislature was discussing is that simply cities could not prohibit them. There wasn't just specific discussion about how cities would establish specific regulations. So if one municipality chooses to apply an ordinance, then they can do so to regulate them. They just simply can't strike out and say this is not an allowed use within our city limits.
So our ordinance states that if you're leasing, you can't do this for any less than 30 days.
A single family, and it's very clear, and that's why I emphasize it, it states a single-family home in a single-family district. If you have a single-family home in a multi-family district, that starts a whole other conversation. But in this case, these properties are zoned single-family. They are single-family residences. Therefore, that line of the code does specifically apply.
Okay, so if what the residents are alluding to is true, and these are potentially people who are less than 30 days, and this is being operated in violation.
Correct.
Okay, thank you.
Commissioner Zarguni.
I just want to clarify, Commissioner Schrader. So when you say in 30 days, is it per one family? Like one family stays within 30 days? In other
Correct.
words-
It's the key phrase would be single-family home. So you could only have one family, as you mentioned, staying there. The hard part is proving what is a quote-unquote family, and that's been a very long discussion of how to define that. But nevertheless, the goal would be you would have one group, not two different parties, Group A and Group B staying. Now you're getting into a multifamily situation. In this case, they are still, first and foremost, single-family homes.
And the reason I'm asking this is because I heard one of the lady mention that they have a daily night of $199 to $400 per family. So am I understanding that currently the current owner is violating the rule because they renting
If their claims are true, and of course, code enforcement or our compliance officer would need to validate that through an investigation, then yes, they would be less than 30 days and therefore non-compliant with the UDC.
Okay, thank you.
Commissioner Dibble.
Do we know, has there been any history on this property of code enforcement violations? I mean, has the city been out there and I mean, I totally get the residents' frustration, but I'm just curious, have there been any violations, anything reported, anything investigated at this
I
point?
did ask code enforcement for an update on the property. I haven't gotten that information just yet of how many calls have been sent. Many times, so for instance, the calls that we get into the department, folks will show up with a red placard to say that they are in potential violation. And if they make corrective action, the case doesn't move forward. So if they received a warning and let's say allegations are true, they shut down the Airbnb for a few weeks and then come back up later, that's a separate case that would have to be generated according to how code enforcement explained it to me, since they technically came into compliance and stopped the illegal activity.
And then I guess under this ordinance, this particular house is a 3-bedroom unit, so the owner would have to occupy one of the bedrooms, I guess, to be on site. And
Correct.
then-
Of the 5 bedrooms that the house has, 2 would be occupied by the owner and 3 are eligible for part of this bed and breakfast home.
Okay, so, assuming the owner was there, they could rent those individual rooms for one night or 5 nights or however many nights, less than 30 days.
Precisely.
Because this designation would allow it.
Yes, sir, that's
Okay.
correct.
And then if for some reason, it was suspected that the owner wasn't there, then the resident's recourse would be to call code enforcement. They'd go out and investigate and,
Exactly.
okay.
Commissioner York.
Thank you. You mentioned earlier they could lose their special permit if they had violations, code violations, and they did not rectify that. Do you know, or can you tell us what specifically how that works? Is it one violation, you don't fix it for 30 days, or if you get 5 violations, you're out, or how does that work?
So as far as how code enforcement functions, ultimately a warning is sent to the applicant or to the potential violator and stating clearly what is the means of the violation. They have an opportunity to take corrective action. Sometimes it's as small as 10 days, sometimes as long as 30, depending on the violation. Afterwards, if corrective action isn't taken, a formal citation is issued, and at that point, the person has a choice to either pay a fine and, of course, take the corrective action. or they could challenge it in municipal court. At that point, a judge would hear the case and make a determination if the citation is valid, and then issue a ruling and potentially additional fines or court costs, what have you. And those will keep racking up as the violation continues. So it's kind of like a speeding ticket. If you're speeding, you receive a ticket, and you continue to speed, you'll receive another ticket. And those cases are combined and continue forward.
Okay. And for, for these violations, and we don't know, it seems, if the neighbors have been calling in code enforcement, but assuming they do, a lot of these things sounded like potential violations. So could they potentially get violations, over and over for all of these little things, like the trash, not being picked up, every little thing? Can they all, like you said, just keep adding up and adding up?
Correct. They can keep being cited that corrective action hasn't been taken, or that they're violating specific sections of either the municipal code or the UDC.
Thank you.
Commissioner Gonzalez.
Yes, sir. In reference to the event that this special permit was granted, you talked about code enforcement, actually regulating this permit, asking for the registry. But probably one of the most important questions that I'm thinking of is, in the event, for this special permit to be granted, it needs to be owner occupied. So what steps would code enforcement take to verify that they're actually living there? You said earlier they'd ask for a registry, which I'm sure that, that's pretty easy stuff to show proof of. But in reference to them actually living on that property, what would code enforcement require?
A couple of options you can use. Of course, the simplest one is the person actually answers the door or responds to the code enforcement officer. Second could be using appraisal district records to verify that it is the homestead of the property, and to be homestead, you must be the resident of that property. So there are other means outside of simply knocking on the door to verify that that is definitely not only owner, but owner occupied.
And in reference to what Commissioner York asked, I don't know if I missed it, if you answered it, but when is so many violations that's enough where you actually decide to pull the permit?
That's where we would work with code enforcement, hear a response from the applicant that obviously are they going to try to come into compliance, but there's not a proverbial 3 strikes and you're out. But I think once we get a pretty strong feeling, we would initiate a conversation with our attorney's office and say it's time to remove this permit. We don't want it to let it get to 50 violations, but I think when we see more than a couple come in and nothing is being done, that has to have some form of repercussion.
Okay, that's it.
Commissioner Jewell, did you have another comment?
Yeah, just to try and address, I think, a comment from the HOA. You talk a little bit about deed restrictions. It sounds like within the deed restrictions, this property, even if proposed use may not be compliant with other island deed restrictions. Can you say how that fits in relative to UDC? City enforce?
Sure. So deed restrictions, of course, are private covenants that a property owner would enter into as they join a specific homeowners association. They are not enforceable by city government, as it is, again, a private agreement. So many times, and I'll give you an example, the boat docks that I believe one of the public speakers showed a picture of, those by code have to receive a building permit. So many times they'll come in with their set of plans and say, we'd like to have a building permit, boat dock installed. Great. While not required documents, we ask for a letter from the POA, and the reason for that is it's not that we're enforcing POA regulations, but we want to make sure that they took the chance to visit with their architectural advisory board. And that way, we're not issuing a permit to someone who's going to turn around and be denied by the POA. And that's just good communication we've established with the Property Owners Association to make sure that it's not so much we're permitting something that they've declared illegal or improper in their HOA, but it's not to set up a customer for failure, meaning we're not going to provide them with a permit where they may or may not know that that is not allowed within the bounds of the HOA. So we, of course, provide contact information. If they don't know who to speak to, we give them the contact information we have on file with the POA, and always encourage them, visit with your POA before you come in for a formal permit. We will be here at any time to, of course, help you with that process. But it's better to check all of those boxes before you come in and make that monetary purchase of permits and submit plans.
Commissioner York?
Thank you. Yeah, one more question for me, and it's, can you tell us what the typical response time is for code enforcement? And before you answer, the reason I'm asking is they mentioned the homeowners, noise violations, light violations, potential violations, I should say. And, if the response time, they come out that day, the next day, and, if they're reporting a violation every night for a week, is that one violation or is it 5 violations? How does that work, and what's their response time?
I would probably want someone specifically from code enforcement to address it. I can only address from personal experience where before I worked for the city and working with code enforcement for some issues in my neighborhood, it was within a few days that code enforcement was visiting the site, because I always asked for a return phone call from the officer who was going to investigate the property and give me some idea of, am I correct, am I incorrect in my assumption that it was a code violation. But I can tell you gladly that it's never been more than a 3-day response time in my personal experience. But I don't know their performance metrics as far as how quickly they have to respond, and if there is a measurement goal they need to meet for, let's say, instance, case closeout as it moves through the process. But we can definitely visit with code enforcement and get you that information.
Thank you.
Thank you. Any other comments? Am I not lighting up? No, well, yours are Goonie. I apologize. Commissioner Miller?
Sorry. So, Andrew, I just want to make sure I understand. So the state says that we can't deny short-term rentals, so we have to provide an avenue for applicants to...
There was a bill going through the legislature that cities could not prohibit the use. I'm not sure if that bill actually passed. I hadn't gotten an update on those yet, but that
But
was...
even let's say if it did pass, we would still be able, within our UDC, as long as we provided a pathway to make that possible.
Correct.
Correct? Okay.
We could still regulate, we could just not, we weren't able to prohibit if that bill indeed passed.
So presumably, since there seems to be, relatively good empirical evidence that this particular property has been operating as a short-term rental in violation of the UDC for a period of time since the new owners have purchased it, this would provide an avenue for them to operate somewhat legally, correct?
Correct. Just keep in mind that it's almost two separate issues. So short-term rentals is kind of its own issue that we're contending with, and then this is specifically, as the UDC has had within its pages since 2011, to operate a bed and breakfast home, which is kind of a horse of a different color.
Right.
It's similar but different.
And is there any other than pre-existing overlays or a zoning that allows short-term rentals, is there any other mechanism for a property owner to, within our UDC, to designate their property as a short-term rental?
And that's a very good question, something that we've kind of been wrestling with over the last some time. Single-family homes, as I mentioned, the definition says single-family homes in a single-family district. Checkbox, 30 days. Single-family homes in a multifamily district kind of goes into this void area. It doesn't have a specific definition, but another page of the UDC says if something is not specifically listed, it isn't granted because it's simply not listed. And then option 3 is anything that's going to fall under what's called an overnight accommodation, what's typically a hotel or motel use. Now, some apartment complexes could put within their requirements that they want to have shorter rental periods than your typical 6 or 12 months. They usually don't because of the high turnover, and they're not in the hotel business. That also leaves the door open for planned unit developments, which we've seen quite a few come in the last few months. Planned unit developments have the opportunity to put a line within their specific design standards to say, we would like to allow daily, weekly, and monthly rentals. So that is a quote-unquote legal way to go about the process. And as you know, there's more than a few of those. Then, of course, we have condos, which also fall under technically the overnight accommodation use. Within their private covenants and deed restrictions, they can also allow a shorter period, under 30 days type of rentals. So the UDC does provide options. Typically, it's on a much bigger scale where you're going to be able to meet all the different commercial standards of ADA compliance, fire sprinkles, all those type of things that you'll need for an overnight accommodation use. You usually won't see those on the micro scale of a single-family home. So that's, in a nutshell, where we are and how the UDC fits in.
And if the property owners decide that, or let's say this thing did get approved, and would it be reasonable for, or is it possible for development services to request, proof of homestead exemption on this particular property? Because a quick search of, Noise County Appraisal District shows that this family lives in San Antonio, and this is not subject to any kind of homestead exemption. So, would that be a reasonable or possible request that, this is all contingent on or dependent on you making this your primary place of residence?
So I would say, and before Buck probably shoots me a negative glare, but I would say since it's a special permit, you can add conditions. Otherwise, it would have to be a text amendment to this section of the UDC to add that requirement at face value. But I want to say, as this is a special permit, you potentially could add a specific condition to this use.
And I'm not sure if that, yeah, I think you could add a special condition to the special permit that the property be homesteaded, if that's what you're asking.
Yeah, I'm just trying to think of, any kind of way to ensure that, because if you've got these residents calling code enforcement for violations, and you've got a group of guys or gals or family or whatever in this particular residence that has
Sure.
at least for a weekend, and there's a 3-day response time from code enforcement, and they're long gone by the time they come back. This is kind of going to be a chasing your tail situation, and I'm very sympathetic to the situation that that the homeowners are up against here. So, be interesting. That's all I have.
Thank you. Any other questions for staff or any other comments?
Yeah,
Michael,
one
you-
more. Wondering if you can just clarify something for me. I read something recently, and so maybe I'm just way off or this was wrong, but I read that the city, I believe, is going to restrict short-term rentals on the island to the east side, the non-single family side, and I don't know if that's just something they're looking at doing in the future. And the other thing I read, and that the enforcement was no longer going to be code enforcement. And I don't remember if that was a city news or if that was POA or it's probably in the Island Moon where I read it. But can you shed any light on that?
The second question, code enforcement, animal care services, and I believe our homeless division, several departments have been lumped now under neighborhood services. So it's a new kind of umbrella department covering several divisions. So code enforcement does no longer exist on its own or part of PD. The first question, I'm not directly aware of any type of movement towards rezonings or changes of the UDC specifically to restrict. As you know, we don't have a specific short-term rental ordinance, so that would need to be worked out as part of that process, which I'm sure there'll be a very long discussion, very open to the public, of how we would go about that. The only ideas that I recall back from 2018 was to start a pilot program and pick specific areas of the city that are more tourist-oriented, which would kind of fit in, if that's what you read, of that idea of starting somewhere to find a way to bring them into conformity. But I'm not directly aware if those conversations have continued.
Okay, thank you.
Any other comments? Yes, sir.
Just for the record, is this Mr. Morales and Mrs. Morales' current homestead right now? Is it already?
I do not believe so.
You don't believe so? And do you know if they reside in Nueces County?
That I do not know of, but from what I read on the last NCAD results in the appraisal district, it was not a homestead property.
It was not. Okay.
Thank you. Any other comments? Okay, at this time, I will entertain a motion or further comment. Item 11.
This is Commissioner Miller. I move that we deny the requested zoning change at 13845 Mizzen Street.
Second.
Commissioner,
Second.
Okay, I have a motion and a second. Can we call roll, please?
Who is the second?
Commissioner Schrader.
We have two.
Okay, a vote of no will not be supporting the motion on the floor. Chairman Baugh.
Aye.
Chairman Dibble. Vice Chairman Dibble.
You got me
Vice
confused.
Chairman Dibble,
So,
sorry.
if I say aye, I am supporting Miller's recommendation to deny? Yes, aye.
Commissioner Schrader.
Aye.
Commissioner Zarguni.
Aye.
Commissioner Miller.
Aye.
Commissioner York.
Aye.
Commissioner Gonzalez.
Aye.
Commissioner Mandel.
Aye.
And Commissioner Salazar Garza.
Aye.
Motion passes.
Thank you. All right, moving on to Director's Report. And thank you all for the comments. You don't have to stay for the rest of this unless you'd like to. We are a recommending body. It still goes to City Council, so show up there and make your comments known again. So thank you all.
Thank you, Mr. Chair. I just wanted to make the commissioners aware that this Friday, there'll be a Development Services Task Force meeting. We do that every month, the second Friday of every month from 9 to 10:30. So all of you should have received a WebEx, so if you are available, please join in. The second thing I wanted to make you aware of is this month, we start our technical review of the 2021 codes. Several of you are on the committee, so that should be very exciting. And I'll bring sort of bi-monthly updates on where we are and what we've discussed. Thank you.
Thank you.
Did you say that the task force meeting, it's not in person?
Not yet, because I haven't found a venue just yet, but it will be soon.
Okay. Thank you.
Okay, if there's nothing else to discuss, the meeting is adjourned, and we will convene the Beach Dune Committee. Can we please call roll?
Chairman Baugh.
Here?
Vice Chairman Dibble.
Here.
Commissioner Schrader.
Here.
Commissioner Zarguni.
Here.
Commissioner Miller.
Here.
Commissioner York.
Here.
Commissioner Gonzalez.
Here.
Commissioner Mandel.
Here.
And Commissioner Salazar Garza.
Here.
Quorum established.
Thank you. At this time, are there any public comments not related to a specific agenda item? Seeing none, move on to absences, which are none. Moving on to minutes. Does anybody have any comments, or do I have a motion to approve the minutes?
Commissioner Gonzalez, I'll make a motion to approve the minutes.
Second.
Thank you. We have a motion and a second. All in favor, say aye.
Aye.
Motion passes. Moving on to the public hearing item C.
Good afternoon, Commission. Craig Garrison, City Planner, Development Services. All right, tonight we do have a application number 21BD1004. That's Richter Architects Incorporated, and it's application to construct an outdoor chapel at or near 7013 and 6981 State Highway 361. Subject property is located seaward at 6981 State Highway 361. The current use of the property is a convention center. And these are the UDC requirements for your review of a beachfront construction certificate. If y'all would like, I can go over the requirements again, or I can just glance through the slide.
That'd be fine.
All right. The reason that this application is coming before the Beach Dune Committee today is that the proposed location of this outdoor chapel is seaward of the 350-foot beachfront construction line, or also known as the Nueces County construction line. As you see in this map, I apologize for the map size. It is the third line on the map is the erosion response line or the Nueces County building line. The second line is your 200-foot line where there's a prohibition on all concrete structures or any structures of any kind. Within the 350 feet erosion response line, anytime you're building anything above a recreational amenity or a beach dune walkover, it shall be reviewed by the Director of Development Services and also by the Beach Dune Committee. This slide does show the 350-foot erosion response line. And if you do remember from our last beachfront construction certificate, the line has moved 20 to 40 feet landward in some cases because of Hurricane Hannah last summer. At this location, the chapel was proposed at a location that is also seaward of that 350-foot line prior and after Hurricane Hannah. It is currently proposed 312 feet landward of the line of vegetation, which I'll remind you that is the benchmark for our 350-foot building setback line. In addition to this site plan is the orange shaded area, which is your erosion response area. Part of the beachfront construction certificate is an erosion response permit as well, in which they have to document all land that will be disturbed during the time of construction, and they do have to prove that that land will be remediated with a dune or further vegetation further seaward from that site, and they have proved that to staff, as shown here in the erosion response plan. And just a reminder, the requirement for this erosion response plan is because of our joint erosion response agreement with Nueces County, the General Land Office, and the City of Corpus Christi. And as you see here, there will be mitigation of a dune seaward and also mitigation at the line of vegetation. These are chapel floor plans. This is the subject property viewing north from the beach. It's the subject property from the dunes towards the existing conference center. This is the view looking south. And 3 notices were mailed in the 200-foot buffer. We received one notice in favor. We do have a added notice in favor to the north. And staff's recommendation is denial of the beachfront construction certificate. Staff awaits for any questions.
Thank you. At this time, do we have any comments for staff regarding this item? Commissioner Miller?
So tell me again, what is the, how much is the structure infringing on the 1,000-foot, or sorry, the Nueces County line?
It's 38 feet.
38 feet.
Encroachment, yes.
Okay. Thank you.
Commissioner Sheldon, or Schrader, sorry.
In the letter that the GLO sent out, they indicated that they needed to receive a revised Nueces County dune protection permit, and I believe I understood in there that they had received that revised approval. Correct?
That is correct. This application was delayed because they did have to sign up for the Beach Management Advisory Commission, and they were approved by Nueces County for construction seaward of the 350 feet.
Okay, and what was the rationale for that approval, or did they provide that?
Yeah, sitting in on the meeting, there was just one commissioner on the committee that did want to leave all structures outside of the 350 feet, that they did adopt that line for a reason. The rest of the commission did articulate that it was an outdoor chapel and it was a master planned project. It is master planned since I believe 2003. I do have the applicant here that can correct me on that date.
Other than that, it was about a 30-minute meeting. Is pretty quick. So.
Okay, and in the current recommendation, the city's current recommendation for denial, what are the key points, I guess, for that position?
Yeah, the key points were we do have this joint agreement with Nueces County and the state, and we are working to uphold that prohibition of structures. The first point is that we do have a large amount of dune loss every single year. It's an erosion at that line of vegetation, right? And these dunes is what's protecting development all along Mustang Island, all along coastal islands in the state of Texas. So having more structures and having construction close to that line of vegetation doesn't allow those dunes to kind of reseed themselves and solidify again. The next was that we talked with our assistant building official, Luke Fry, and he dubbed the project an occupiable structure instead of a recreational amenity. If it had fallen into the category of a beach dune walkover or maybe just a small kind of birding locale, staff most likely would have recommended approval. But because the intention of the site is to have meditation and to have meetings there long term, and it is actually a covered structure as well with a bell tower, that we upgraded it to occupiable and not a habitable structure, right? Nobody's gonna be staying there, living there. Just upgraded it from that classification of recreational structure. So those are the two major points.
Okay. And then I guess in looking at the drawing details provided, it looks like that this is essentially a permeable structure, and it is largely, it is not in the traditional sense an impermeable structure. So it is to some degree less disturbing to the site potentially than something. I mean, in other words, it doesn't have a concrete foundation. It doesn't have things like that. So it is somewhat different in its structure than, because I saw that was a point that the GLO's letter made. In some ways, in other words, they allow parking lots as an amenity, but then they say minimize the use of impermeable structure. So, I mean, that was sort of it was countering itself in that point a little bit. But so anyway, but I do understand the points you all made. Thank you.
Yes, sir. Thank you. Commissioner York, did you have a comment?
You said this was a master planned community since 2003. At that time, were there any submittals for, a dune permit or preliminary or other? Was this reviewed and given some kind of preliminary approval at that time?
Staff does not have a record of previous permitting for a beachfront construction certificate. The joint erosion response plan was also adopted in the late 2000s, so it would have been prior to these regulations.
Thank you.
Prior to Hurricane Hannah, would this have fallen within the Nueces County line? You said that there was a setback last year, you said?
Yes, along Mustang Island, we lost 20 to 40 feet of dune, so therefore the line was pushed back 20 to 40 feet. This would have fallen within the 350-foot building setback line at that time.
So because of the change now, it's about 38 feet, you said, outside?
Yeah, so in this area, I do not know the exact amount of dune that we lost, but it does show that our line moved about 20 feet in this area, so it still would have been it would have been 18 feet shy.
Oh, okay, I got you. Thank you.
Commissioner Miller?
So I just want to make sure I understand a couple things. The roof structure, is it more of a trellis or is it actually a solid, non-permeable structure?
I do have the applicant here that will be able to discuss the composition of the project. Okay. It does seem more like a trellis.
Well, we can address that in a second. The other thing, I guess, more towards that would be in your wheelhouse would be, if I'm understanding you correctly, if it did not have a roof and did not have the bell tower, it would classify as more of an amenity and not an occupiable structure?
Yes, the General Land Office actually has a dune protection and improvement manual for construction, and they actually line out how to do beach dune walkovers, how to do vistas. They do like actually the inchage between each board, right? And the type of wood you're going to be using. No concrete. Concrete's prohibited. So they're very specific as far as the type of construction they want to see in this area. The roof is a key, I guess, strike against the structure for meeting those requirements.
So, basically, if the roof went away, we wouldn't be or the staff wouldn't be recommending denial?
That's a possibility, yes. If the roof was gone and the bell tower, then it would be more of a dune walkover.
And
and that is a recommendation from staff, and the staff report was that if they did change this structure to meet the general land office's requirements, then staff would approve.
And then the other, obviously the other compromise would be to move it back 38 feet.
Yes, sir.
Okay. All right, thank you.
And to clarify, nothing is enclosed, correct? Just a roof structure?
Nothing's enclosed.
Awesome, thank you. Any other comments before I open public hearing? At this time, we open the public hearing for comment.
My name is David Richter. I'm a principal with Richter Architects. My address is 1386 Sandpiper. I have been involved in this project since its onset. Aaron Geiser is with my firm. He's here to help me with some details because he's been more involved in the sort of bureaucratic approvals, and I've been at a little more of a high level. I'd like to first comment by clarifying a little bit. As pointed out, it's an open structure. The bell tower is a series of timber piles. There's no walls, there's no roof. It's like a series of 6 or 8 open timber piles. So it's really no different than a pier or a walkover or anything. It just has a bell up there. There is a roof, but it's primarily a shade structure. It's up at a high level so that sun penetrates at all angles. There are no walls anywhere on the building. The deck is at a fairly high level above grade, so from the western side, sun penetrates deep below the deck to help with vegetation underneath the deck. The location of the chapel is where the chapel has been located since the master plan was prepared, roughly in the year 2000. And was approved. It did have a master plan approval by the Nueces County that had a approval for about 10 years. Ultimately, it expired, and we then were faced with a series of new regulations associated with the project. The chapel has always occupied a very strategic position in the overall plan, and I'd like to emphasize, if I may, the overall plan. We're focusing today on the chapel in 38 feet, whether it should be here or there, 38 feet. But the Mustang Island Episcopal Conference Center, in its inception, debated in themselves as a client, as an owner, whether they should build at all. They were so environmentally focused on the ethics of building on the island. They almost didn't build the project at all. And in the end, our firm, in assisting them in evaluating this, came to the judgment that the island is going to develop. And if they could develop with such a high bar of environmental sensitivity that it could be an example for development up and down the island, it would be better for them to develop than to leave it alone. And they set a high bar where all of the buildings are far behind the dune line. The only building that's contemplated to be even close to the dune is the chapel, which effectively is exactly like structures up and down the beach that are considered recreational amenities, typically by public entities, in the form of pavilions that exist several places up and down the beach. The only difference with this one, I'm not sure, is that it's not a public entity, and maybe it's a little bit bigger footprint than some of the pavilions. But several of them have shade structures just like this does. They have elevated decks, very, very similar. So the chapel is important to the mission of the Episcopal Conference Center because it's the place where they gather and they appreciate the beauty of the island And not just the dunes, not just the beach, but the wetlands, the grasses, the 22 acres of the entire project, respects and protects dunes everywhere, not just along the dune line. But there have been no dunes disturbed as this project was built. They were built between the dunes, where dunes came close to the building. Retaining walls were placed to allow the dunes to accrete and erode in nature, just like they do anywhere else. There's no manicured lawns. There's no parking lots, really. The only parking lots are with recycled concrete to allow permeability, and under some of the buildings where the shaded areas have destabilized the ground plane, and so park under the buildings because that's where it's destabilized. So virtually the entire site is protected for dune erosion, accretion, for Mother Nature to have her way, not just at the edge of the dune line. The dune line that we are affecting for this project is 17% of the frontage. If you look at developments all up and down the beach, you will find that whatever is happening, it's happening across the entire frontage. That's where the valuable property is. That's where people push it as close as they can get to the dune line. This is 17%, and we want to take 17% just that far over, only because the line has moved as the years have gone by. If we were to try to move it back, we would either have to extend the piles because the dunes fall down to be much taller, which would render the lateral stability of the chapel such that we really couldn't build it. The structure would have to be beefed up to the point where the cost would become insurmountable. Or we have to lower the chapel to where it loses entirely its vista of the water. And right now, it just has glimpses of the water between the dunes because it's important to the conference center to have that balance, to not just be all about view to the water, but to be respect to the dunes, the grasslands, the wetlands, everything. But moving 38 feet or 40 feet to the west would effectively render this project impractical and much more costly, and it would compromise the functionality of it and its ability to be a place where people come and learn how to respect and enjoy the nature of the island. So it's a very significant situation that we're being asked to do, simply because this particular open air, no walls, not much of a roof, a shade structure, is, I don't know, marginally different than others that have been deemed to be recreational amenities up and down the beach. So we have county approval. We understand that we are getting the GLO approval.
Right. And GLO has already approved this as a recreational amenity when we received the permit to start off with as well.
I think the only thing pending on that is that we have an amendment to the
For some temporary disturbance.
for temporary disturbance, which was not in the original plan. So we've amended with the temporary disturbance. That's going back. In the meantime, we have a contractor that's held up. It's costing them money and the client money, and it's actually kind of a tragic situation to be honest, because I've never had a client work so hard to be environmentally sensitive. I think if you were to drive the beach up and down, in fact, when we first built the project, designed the project, we traveled all up and down looking for prototypes for really, really environmentally conscious architecture that really was at home with the ecosystems on the beach. And we didn't find anything, and we developed this prototype, and it was nationally published by the USGBC. It was featured in a conference in Miami for environment back in 2000, and it's been actually celebrated as one of the most environmentally sensitive projects on the Gulf Coast, and we do recognizing we're putting a toe across this line, but it's not casually, and it's not trivially, and it's not without pretty sound basis. So we respectfully request that you consider that big picture, because this is a white hat client. These people are occupying the island in as careful and a respectful a way as is possible. And I hate to see them punished for it.
Thank you, Mr. Richter.
And one last thing, and as a trade-off as well, too, we also propose that we have a 20 by 110 foot at that vegetation line that has been eroded, that will reestablish that frontage in front of the chapel at that's at the new vegetation line that was eroded. So that was a trade-off, and the GLO said, well, if you do that, then we'll allow you to have it seaward of that 350.
Thank you. Commissioner Miller, do you have any questions?
Oh, just my previous question about, is the roof, I can't read this because it's real fuzzy. Is the roof a solid?
It is a solid
It's a
structure,
solid
yeah.
roof,
Yeah.
but it's open on all four sides.
It's open on all four sides, and it's got significant height to it.
But if let's say a compromise was recommended, I mean, would it, if that was a lattice or more of a trellis, would that be, how would that impact the integrity of
If
the?
it was that's a good question. We debated whether to do it as a trellis, and we could probably make it effectively a shade structure, which is its primary goal. It would render it not habitable if it was rained and.
But if it was raining anyway,
it's not likely. Yeah, I mean, unless the rain just sort of pops up on them.
Down. Yeah.
But honestly, and I know, and I totally respect that you all have rules and you have to deal with the rules and are trying to help us. I know that, but we all know that the environmental impact of it being a solid versus being a trellis is zero. I mean, it doesn't affect the vegetation, it doesn't affect the ground plane, it doesn't affect anything except whether or not somebody's going to get rain on their head.
But how is the water that's going to sheet off that roof, how is it going to be? Is it just going to fall off the side, or is there going to be a collection system or gutters or downspouts?
Currently, it's just discharged, yeah.
Okay.
Thank you. Any other questions for the applicant? Any other comments?
No, I apologize for taking so long, but I felt like it was important background information.
Thank you. Appreciate the comments. At this time, we will close the public hearing. Any other comments for staff or any other comments amongst ourselves?
I just wanted to clarify with staff. I believe Mr. Richter said that this has been approved by the county and the GLO as an amenity as it's been drawn?
That's currently incorrect. The prior approval from the GLO was in, I believe, January or early last year, and it did not include their erosion response plan of the total impacted area. All it showed was just the chapel kind of being constructed out of thin air, right, with no construction vehicles tearing up the dunes. Once they did show that erosion response plan, we have not received any new approval from them on this plan, to our knowledge.
So, but that aside, they approved the structure as submitted without its, their permeability requirements.
Yes, it does seem that the GLO did initially view the structure as a recreational structure, and then in their letter from April 30th, put the ball in the city's court as far as the determination, as far as what type of structure it is.
Okay, thank you.
Yeah.
Okay, at this time, further comment or a motion?
This Commissioner Miller, I move that we approve the requested, sorry, I don't have my agenda.
Construction certificate?
The requested construction certificate for the beachfront as presented.
Thank you. I have a motion. Do I have a second?
Second.
Second.
A motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. Motion passes. Do not have a director's report for this one. It appears the meeting is adjourned. Thank you all.